And for more on how the High Court may deal with this enormous issue, we're joined this morning by Kenji Yoshino of the New York University Law School. He is a specialist in constitutional law, now working on a book on the Proposition 8 litigation in California, and Suzanne Goldberg, a professor of the Columbia University Law School and director of Columbia's Sexuality and Gender Law Clinic. It's so nice to have both of you with us. Good morning.
Good morning.
Kenji, what's at stake here?
Well, I mean, a huge amount is at stake with respect to the equality and the equal treatment of same-sex couples under the Constitution. And so what the two issues that are being teed up in these cases are, first, the equality claim of can you say that you're treating gay couples fairly if you're denying them access to marriage? And then second, a fundamental right to marriage claim, which is to say, shouldn't all Americans have the right to marry the person that they love?
Suzanne, is one of these cases ultimately more important than the other, do you think?
I think the two cases are enormously important, but they're quite different. Right. So the Proposition 8 case is really about marriage at the state level.
Yeah.
What do states have to do? Do states have to recognize same-sex couples' marriages? And the second case, the Federal Defense of Marriage Act case, is really about the federal government. Can the federal government deny benefits to same-sex couples who are already married?
And the Supreme Court is going to be looking at this question on a constitutional basis. What will be the arguments that we hear in that court?
Yeah, so with respect to the Prop 8 case, it's both the equality claim that I mentioned and the right to access marriage claim, the fundamental right claim. With respect to the Defense of Marriage Act claim, it's only an equal protection claim, because the idea there is, look, these individuals are already married in the states that provide marriage.
Nine states.
Exactly, 9 states in the District of Columbia. The fact pattern of the Windsor case is actually a really good way of bringing Suzanne's point home, which is to say that Edie Windsor was with her partner for 40 years, married her in Canada, which was recognized in New York at the end of their lives, at the end of Thea's life. When her spouse passed away, Edie was deemed to be her wife for the purposes of New York law, so Thea's remains were released to her, for example. But in the eyes of the federal government, they were legal strangers. So if she was hit with an estate tax of $363,000, which would not have been levied against her had she been married to a man.
So what are the arguments going to be in favor of keeping the status quo here?
So the arguments for the status quo, the main argument in these cases tends to be that marriage should be reserved to different sex couples because different sex couples can procreate accidentally.
Right.
Now, most people might think, well, that's not what my marriage turns on.
Yeah.
But that tends to be the argument. And the response to the argument has been two things. One, that denying marriage or denying the marriage benefits to same-sex couples has nothing to do with whether heterosexual couples procreate accidentally or whether they take responsibility for their children. And the second point is that, as the American Academy of Pediatrics has shown for many, many years, and as many other professional organizations have shown, there is no difference in the parenting abilities of gay and non-gay parents. And so the idea that parenting discrimination would come into marriage discrimination really makes no sense.
What do we expect the outcome to be here? And could it be something along the lines of, we're going to make this a state-by-state issue versus a federal issue? Is there room within what's on the table right now for that to be the case, as it has been previously?
Yes, absolutely. So with respect to the DOMA case, I'm quite bullish on this. I'm pretty confident the Defense of Marriage Act will get struck down, in part because even the conservatives in the court tend to be states' rights advocates, and marriage has historically been deemed to be an issue of state law, right? So I think that there's going to be a conflict because the right wing of the court tends to be less pro-gay, but they tend to be more pro-states' rights. And so DOMA, which interferes, with states' rights while being, anti-gay, presents kind of a problem for them. So I think that's going to go. I think that's very constitutionally vulnerable.
Yeah, I tend to agree with Kenji. I think we're at the end of the day for the Federal Defense of Marriage Act. The California Prop 8 case is a little bit different because I think if we get to the equality question, it's pretty clear that there is no legitimate reason for states to treat gay and non-gay couples differently for purposes of marriage. But there's a first question, which is, can Proposition 8 sponsors actually ask the federal court to take their case? And they're private citizens, so they don't have the same rights as the government there.
Suzanne Goldberg, Kenji Yoshino, thanks so much. Appreciate it.
Thank you.
Thank you.